I just pick up a question that was asked of me before lunch, which was what are the documents relied upon as evidence of collaborative approach between the applicant and this housing authority? The other of the documents I draw to the court's attention is also the money assessment forms and the self-medical assessment forms completed by both the applicant and her son that can be found respectively at SB 90 and SB 232.
90.
232. And the reason I describe them as important documents, this is the applicant's chance to give quite a detailed account of what they say that their needs are.
Before the assessment. This is all before the assessment.
That's right, that's right.
It's the gathering of information by Barnet.
That's right. And the point I'd make about an assessment is I would endorse or respectfully adopt the approach the administrative court has taken to assessments and housing needs assessment. I think Mr. Colville would agree with that. Is it doesn't have to be contained in a single document. We're looking at a housing file as it would appear to a sensible housing officer.
It's a process rather than a document.
Yes, yes.
But the judge found there was an assessment. That's not challenged. He found it was deficient in the way that he identified or assumed it was deficient. That's not challenged, and the subsequent review is not challenged. And that certainly, speaking entirely for myself, sets the parameters.
And I would respectfully agree with that. I would say that the review decision itself is also a complete answer to it, because it was a review of suitability, and it looked at all matters as at the date of the review. Because of course in these appeals, although the appeal is against the judgment, what this court is concerned with is the review decision itself and the lawfulness of the review decision. But yes, I would agree certainly with that, Lordship. If I may just briefly come back to Norton the Haringey, just to sort of wrap up that submission, because of my respectful submission, there is no material distinction to be made between this case and the Norton and Haringey case. Norton and Haringey was concerned with a suitability review, so is this, and I'll pick up all the threads of that later, the significance of how the review request was framed. And in Norton and Haringey, there was no extant complaint about suitability. And again, I say that's the feature here. It's not suggested that the property is unsuitable.
Well, you may be right, but certainly in his reasoning, Lord Justice Lewison makes reference to the contrasts between the terms of the legislation he was concerned with and other provisions, including section 195.
Yes,
So
that's right.
paragraph 47, he expressly draws attention to that contrast, that there is no such cross-reference.
That's quite right.
In section 210.
Yeah.
Now, if that's of no legal significance, why does Lord Justice Lewison draw attention to it?
Well, my answer to that is going to be twofold. As Barnet's case is, it was conducting a suitability review. If I'm right about that, suitability, if you perform or discharge the prevention duty with an offer of suitable accommodation, if that's what you rely on as bringing the duty to an end, the provisions on suitability govern that offer. So that's section 205 to 210 of the Housing Act 1996. And so Lewis made the point that section 210 does not cross-refer to section 189A. So that would be my first point.
That once more. Suitability is covered by sections 205 to 210.
That's right. If a local authority performs its prevention duty by securing accommodation is actually available, section 205 provides that all the provisions relating to suitability, which is what what Norton was also concerned with also apply to that offer of accommodation, to the suitability requirements. So that'd be my first point. My second point is where section 1953 cross-refers to the section 189A assessment, that's in the context of the reasonable steps the local authority is going to take. So that's section 193, and deciding what steps the authority are to take, they must have regard to the assessment of the applicant's case. So pausing there, the section 193(2) duty, sorry, the section 195(2) duty, the prevention duty, is to take reasonable steps to help the applicant secure that accommodation does not cease to be available. It is not a duty to accommodate, it's a duty to take reasonable steps.
Yes, I was wondering about the wording. To take steps to ensure it ceases to be available.
Yeah.
What does that mean?
Does not cease to be available. So that would be similar, and in fact I say that's what actually happened in this case initially when the applicant didn't wanted to remain in her current accommodation. So the steps authority might take to ensure that accommodation doesn't cease to be available might be to liaise with the landlord and say, can she stay or can he stay? Is it a question that you want to increase rent? Because a reasonable step might be to make some sort of discretionary payment if there are rent arrears. It could cover a whole host of things to prevent or to help secure that accommodation does not cease to be available. But if the local authority then decide to give notice saying the prevention duty has come to an end, one of the circumstances in which it's entitled to do so is under section 1958 of the Act. One of the circumstances in which it can end duty is if they're satisfied the applicant has
Sorry, which section is it?
section 1958. So I asked you to look at section 1955 first. It probably makes it all make a bit more sense. If any of the circumstances mentioned in subsection 8 apply, the authority may give notice to the applicant bringing the duty under section 19 under subsection 2 to an end. If I call that the prevention duty, one of the circumstances in which an authority may give notice are set out in section 1958 if the authority is satisfied the applicant has suitable accommodation for occupation and a reasonable prospect of having suitable accommodation available. So I said that's what happened here, but pausing there, that notice requirement doesn't cross-refer to section 189A. So I say that brings us back to Norton and Haringey. And
So the principal duty under 1952 is to take reasonable steps to help the applicant secure that accommodation does not cease to be available.
That's right.
That's focusing on the applicant's current accommodation. All right?
Yep.
And in that context, in deciding what those reasonable steps are, the authority must have regard to the assessment under 189A. But where 8B applies, where subsection 8 applies, your case is this your case?
Yep.
The duty, there's not a duty at that stage to have regard to the section 189A assessment. Is that what you're saying?
Well, I'm not saying there's not. Regard might still be had because it might still be relevant, but I'm drawing the distinction that doesn't cross-refer to section 189A, the same distinction that I would say Lewison made in the Norton case. But it doesn't alter the ultimate outcome, if you like, because when an authority is discharging a duty by securing accommodation, that accommodation must be suitable. And one of the things that the local authorities must have regard are all set out in section 205 to 210.
But the specific, you say there is no specific obligation
not in relation
under
to
189 and 189A in the context where subsection 5 and the particular subsection 8 applies. Is that your
that's
case?
right. So I say that brings us back to Norton. That's why I say Norton is relevant, well, is binding and does answer this appeal. If not in whole, then it goes a long way to it, because of course there's one passage in Norton which, as your lordship observed, could possibly help the applicant, and that is paragraph 31, I think, off the top of my head.
Yes.
If a decision is based,
Legally flawed.
yeah, that's right, absolutely. So what I would say in relation to that, and why I say it doesn't answer or doesn't help the applicant, was a point I made briefly just before the lunchtime adjournment, was in all the cases that of course we was considering in Norton, all the administrative cases, those were all cases proceeding in the administrative court, challenges to section 188 accommodation, which is the interim duty. So there's no right of review against accommodation offered under section 188, and there's no county court right of appeal. And in the case of XY and Haringey, the court made a finding of fact that the decision on suitability was based on an unlawful housing needs assessment, and housing needs assessment was being challenged, it's squarely being challenged. I say in contrast to this case, where there has been the internal review and a subsequent, well, not just a review, a minded to letter as well, in fact. In contrast to the facts of this case, it can't be said that the review decision on suitability was based or determined or predetermined, if you like, by a housing needs assessment, because that's not how the scheme of the Act works. If I take you to the review decision first, because court appeal hasn't been taken to it yet, which I say makes good my proposition there. So the review decision itself.
Just before you leave the legislation, do you mind if I just take you back to the terms of section 195? I'd just like to know what your submission is about subsection 3. Whatever may be said about subsections 5 and 8, subsection 3 does
Yes.
expressly cross-refer to section 189A. And as I understand him, Mr. Culver's fundamental submission is that that is mandatory, must have, regard. So it's not about securing any particular accommodation, but that it is an obligation to have regard to something in reaching a decision under subsection 2 on what steps they are to take. And what he says is that if you're right, then a breach of subsection 3 has no practical consequences. And that can't be right, he says, because Parliament shouldn't be taken to act in vain. It was obviously trying to do something in 2017.
Yes. Well, in my submission, it doesn't mean that Parliament is acting in vain. A local authority is required to have regard to the assessment when deciding what steps to take under section 1932. But having, in my submission, having regard to is not the same as it redetermining the outcome. It's just something that must be considered. So they must have regard to it. But I do see an important distinction with why that doesn't answer this case is what the local authority was being asked to review was suitability. It wasn't being asked to review the steps it was going to take. It was being asked to review suitability. And I say that's what it did.
Does section 1955 apply here? Did the local authority give any notice?
Yes, so the notice appears in the bundle at page, supplementary bundle at page 50.
Right. That's a notice under 1955.
That's right. So that brought the duty, tell them notice that the prevention duty was coming to an end, and sort of pausing there, and I'll pick this up again on my third overarching submission.
Before serving such a notice, the local authority has to be satisfied of the circumstances that the circumstances fall within subsection 8.
Yes.
And your case is, or part of your case is, that when deciding whether it is satisfied that the circumstances fall within subsection 8, the local authority is not under a duty at that stage to have regard to their assessment under 1898. Is that your submission?
I'm not. No, that's not quite the submission I'm making. I probably didn't express it very clearly. I think the point I was trying to make on it was, in Norton and Haringey, one of the factors the court took into account was the fact that section 210, which is the suitability provisions, doesn't cross-refer to section 189A. And the point I'm really making here is, well, that's also true of when you'll get serving notice to bring duty to an end. I won't go as far as to say it's not relevant, because it's part of the overall assessment, and when an authority is reviewing a decision, it's looking at all the matters that it considers relevant. So I wouldn't put it in those terms.
This is a question which vexes public law generally, but I think Lord Justice Lewison addresses it, because the point he makes is it's not a mandatory relevant consideration. That doesn't mean it's not relevant.
That's right.
And in public law, it's referred to as permissible.
Yes.
Relevant consideration. So in other words, you are allowed to take it into account. It's not irrelevant.
Yeah.
But there is no duty
Yes.
to take it into account.
Yes. In contrast to section 193, section 1953, where they aren't being
Exactly.
applied to. So we were looking at the notification. I mean, I'd make the very sort of brief point there. There was never any request for review of that decision. Is now a convenient time to look at the review decision itself?
Yes. Thank you. Where do we go for that?
So that appears in the appeal bundle itself
Ah, right.
at, thank you, 118. So the points I'd make on the review decision itself is, in the very opening paragraph, the applicant had requested a review of suitability, so that's what was being done. And I'll pick up why I say that's significant on the facts of this case. So that's paragraph 1. At paragraph 4, I've had an opportunity to review the file. You'll have seen also this was a case where there was a minded to decision sent. So at paragraph 7, minded to decision was on the 16th of June, and paragraph 7 refers to the fact that there was a response to that which was also considered on the review. And then at paragraph 8, in addition to the housing file, I've taken into account all those representations and the views being considered on the facts before me as at the date of this review. And then at paragraph 14, the reviewer highlights the particular documents taken into account: the housing application, the prevention duty letter, the personal housing plan. But pausing there, my lordships, from the medical report bundle received by email on 28th of June, these are all documents which then post-date the PHP and the housing needs assessment. So these are all further material that was taken into account since the assessment. And then over the page, all the other documents that came into being in representations on a review. The reason I highlight that to the court is a housing needs assessment doesn't determine the outcome of a suitability review. That's a decision made by a senior officer on a review of all the facts as at the date of the review. So even if this court considered there was a deficiency in the earlier stage of the process, say at the housing needs assessment or any other stage, the PHP, any other stage, I say the review decision cures that deficiency. And for that case, for that proposition, along the case of Abed against Westminster.
Yes, do you want us to go to that?
Thank you, Judge. So that's thank you, my Lord. That's in the authorities bundle at
tab 10.
Thank you. So it's at page 230. And this was a case where, again, the argument was being made that there had been an unlawful process in terms of an assessment and the making of an offer. And I'd ask the court to go to paragraphs, we'll start at paragraph 17. So at 17, it's about halfway down, and it rejected an argument for a proposition that if a local authority fails to discharge that duty before making initial offer, it follows that the decision is not only unlawful but wholly ineffective and not one that's been capable of being cured by the statutory review process. And what the Court of Appeal said at paragraph 20 is that the submission to the contrary failed to reflect the significance of the statutory review process. And then also at paragraph 26, the fact that the appellant had failed to challenge any aspect of the review process, making the point that the Part 7 provides an applicant to challenge a decision and have it fully reconsidered to ensure all full facts are taken into review. So I do say that's the second answer to this case. There has been a review. It's not the housing needs assessment which determines suitability, and I say there's very good reason for that, because when an applicant initially approaches, they're interviewed or perhaps seen by a housing officer. The housing officer then perhaps draws up the housing needs assessment and so forth. But when it comes to a statutory review, the review must be taken by an officer senior to the maker of the original decision, and they can't have been involved in the process or in the original decision. So if we take the original decision as being the offer letter, when it comes to a review of that suitability, it's got to be by an officer who is senior to that. And I also say that's also another reason why, as a matter of law, it cannot be right that Parliament intended any deficiency in a housing needs assessment to vitiate any subsequent review decision, because the whole point about the review procedure is to cure deficiency. That's part of good administrative decision making. It gives an applicant a chance to have their case fully reconsidered. So I do say that's also a complete answer to this challenge.
Does it matter that Abed was decided before the 2017 amendments?
No, I say not, because even before the 2017 amendments, assessments were still going on. It's not that they didn't happen. What's happened is they've now been given a formal statutory footing with particular matters Parliament wants to have considered. So I say that makes no difference at all.
And the review procedure itself was not introduced in 2017. It was there.
No, that was in 96.
96?
Off the top of my head, yes. So they used to even before it was introduced, local authorities would still undertake informal reviews and it then go to the administrative court.
And what we get from the 2017 or 2019 changes is BC, 202.1 BC.
Yes, yes.
So you've already, I don't know, we can check it, but it looks as though F was original
That's right, yes.
and G was probably original. And so they had to make amendments to bring in BC
That's right, yes.
to reflect the fact of the new system.
That's right. Which if you're happy with me moving on to my point 3, that's probably a neat point to pick it up because it...
Well, I've never admitted to being happy, but I just want to be sure that you, I understand that you say that Abed is a statement of general principle about the curative effect of review.
Yes, yes.
And the fact that BC is introduced and you've already got suitability, Abed applies.
Yes, yes.
Okay, I think I have understood. I'll be halfway happy. Thank you.
If I can make you very happy by the end, I will...
Well, you don't know. Mr.
Depends how long you
Coleman-
go on.
Mr. Coleman will have a crack at it.
Right, so where are we going next?
So my third point is this was a suitability review. I think I can deal with this quite quickly because you're either with me on this point or you're against me, and it won't make too much difference, I will say, to the outcome. But this was a suitability review. In my submission, it's not fair to a local authority to sort of brush under the carpet the fact that it was anything other than a suitability review. Now, the significance of what the actual review is was addressed in the case of Orofo Addo against Haringey, which appears in the authorities bundle at...
I think I've heard of that.
What authority are doing, Haringey?
Paragraph 12. So tab
12.
12.
Yeah, tab 12 is at 260.
Oh, yes.
So I know the court's familiar with it. I won't sort of labour the point. That was also a suitability review, but the point I think was taken in that decision was that even though the duty had ended, the review decision failed to deal with the fact that the interim accommodation duty continued, but there are no representations at all made about that. And I'll just invite the court just to consider paragraphs 42. But there is no blanket right of review, and actually what an applicant is asking somebody to review is significant, and in fact paragraph 41, which looked at the material difference between the consequences of suitability review and a review under different provisions of other provisions of the Act. The reason I say, and I would adopt all that said there about the significance and why it's significant, because of course a suitability review is going to be looking at different chains of inquiries than another review. So for instance, supposing what had been requested was a review under section 202.1 BCI, the review of the steps. I hope I've got that citation right. I've just done that from memory. A local authority would then be looking at the steps it was taking, and it would go down a different chain of inquiries. So on the facts of this case, actually when the applicant first approached, what the local authority was doing was trying to work with our landlord to see if she could remain. I'm told, I know this doesn't appear in the bundle, but I make the point so you can see the prejudice caused to the applicant, to the respondent, if an applicant is simply allowed to say, well, this comes on, this is, I'm just challenging this decision instead. Barnet were trying to work with the landlord to see if she could remain at the property. It was making inquiries. One of the complaints she made about was mould growth. So it was making sure that actually it wasn't a retaliatory eviction. So had it been asked to review the steps it was taking in performance of prevention duty, it would have led to a different chain of inquiries. So I do make the point that this was a suitability review, and that's what this local authority was considering. I'll leave that point there. I don't think I can say anything more on it than that, unless you have any questions for me about that.
Thank you.
And then before lunch, we looked at the housing needs assessment, and what I say Barnet did. I don't believe I need to. I'll be repeating myself, but I do say this is a case in contrast to some of the other cases like XY and Haringey and UO against Redbridge, where local authorities were quite criticised for not having identified or looked at fairly basic things. So, for instance, in UO against Redbridge, there was a family with school children age, a single mother, and I think she'd been moved something like 8 times between different hotels. They didn't have a kitchen, they didn't have bathroom, they didn't have separate bathroom facilities. I say in contrast to this case, this local authority was actively assessing the applicant's needs. It wasn't that it wasn't disregarded them. She was part of the process. And in fact, in terms of the substance of her complaint, she was aware that it was looking for 2-bedroom properties for her, that they would be adapted. And that's what she got. If we look at the purpose of the prevention duty, I would put it in even more simpler terms. Its purpose is to prevent homelessness. And I would submit that's what happened here.
If you took, say, the hypothetical example that's being referred to during the course of the hearing, where you have somebody in a wheelchair and they're offered accommodation on the 5th floor of a block of flats with no lift, would you accept that that's not, that somewhere along the line the law is being breached?
I would say it would depend on the outcome of the review decision, because the review decision might have a look at that and say, yes, that's absolutely right, that's shocking, I'm going to withdraw the offer and start again. Or, one would hope not, but it might try and stand by the offer, but it might say, I accept there was a deficiency in X, Y, Z, but nevertheless I'm minded to find the property, or I find the property suitable, because we had nothing else at all to offer you, and that was it. Whether or not that would be attractive to a county court judge is another matter. It'd be quashed for being Rensby unreasonable or irrational, but that I would say would answer that.
I see.
The other sort of 2 points I'd make in conclusion. The first point is I'd also draw the court's attention to this was a case where in fact the applicant also had a minded to letter, and the significance of that. No representations ever made in response to that there had been an error. Or that the housing needs weren't properly assessed. I say that's significant for 2 reasons. First of all, fairness. It can't be said it was in any way unfair, or she's lost or been prejudiced in any way. But also in Section 202 review decision, Section 202 reviews and appeals, there is a 21-day time limit for requesting a review. And I say the reason for that, again, comes back to public law principles, efficient decision making and certainty. But also actually, even if this had been a case that was proceeding in the High Court, there's still time limits there. You have your 3 months, you need to act promptly, I should say, first of all, but in any event within 3 months, subject to the court granting any extension. So again, that comes back to efficiency of decision making in public law terms, whereas in contrast here, an applicant is then bringing to the table complaints about decisions that have never been challenged, so I say in public law terms stand unless challenged, but also from events that happened, it could be a year ago. So I say that's another good reason why Parliament has been quite specific about in section 202 what decisions are reviewable and how you go about reviewing those. And then my final submission, unless any interruptions before I get to it, is I say even if you're against me on all those points, this would be an appropriate case not to grant relief. Relief is discretionary. The applicant is accommodated and there is no outstanding complaint about the suitability of that.
Yeah, we just need to be quite clear about the principled basis on which that discretion should be exercised.
Yes.
The traditional view until 2015 was in judicial review generally. It was known as the simplex principle, which was that if the outcome would inevitably have been the same, then the court would not normally grant relief in its discretion. But that was slightly modified by statute in 2015 in the context of claims for judicial review in the strict sense. But I don't think those legislative changes affect the Housing Act appeal to a county court.
I say not, because then it's the county court is acting under the jurisdiction of section 204 and all the case law that applies to that. So I say the point is still the same.
Effectively simplex.
Yes.
Yeah, well, that's a very fair concession, if I may say so. So that's the basis on which you invite us to proceed.
Yes.
That if the outcome would inevitably have been the same, then we should refuse relief. But if, for example, there was a real possibility that it might not have been the same, then the discretion doesn't arise.
Yeah, although I think I'd probably also say in relation to that, if there's a real possibility, it might be, say, an inquiries challenge or a material factor not taken into account, none of which is said to be the position here. And I think the last case I've cited in my authority, perhaps I should have referred the court to it, if I may do so now, it's a case of, is it a Hamid, I think? Just check my skeleton argument.
Yeah.
Hamid against London, which is Hamid against London, which is in the authorities bundle at tab 11. It's page 239.
Yes.
And it is a paragraph. Page 256, paragraph 54.
Thank you.
Which is at the end of it, whether or not that's correct, however important admission could only matter if it somehow resulted in the superdios, the reviewing officer in that decision, being unaware of something significant. There's no reason to suppose that any deficiency in the assessment of personal housing plan affected the decision making. And that paragraph was cited with approval in Norton at paragraph 53, page 328.
Sorry.
It's cited with approval in the Norton decision.
Yes.
That's at page 328 of that decision at paragraph 53.
53. Thank you very much.
So, is it your submission that the outcome would be the same?
Yeah. Yes.
Because all material factors were taken into account in the review decision.
That's right.
Or put another way, nothing has been identified as lacking.
That's right. She was made an offer of property which met her assessed housing need as set out in the banding letter, which you've already seen. It was 2-bedroom, ground floor with adaptions. And it's not suggested there's anything unsuitable about that. And the review decision considered all aspects of suitability, including location. Sorry, I got sidetracked. I didn't go into all of that, but the review decision did comprehensively address location and location in relation to support networks. Would you like those paragraph references?
Does it amount to this, that your submission is that on any real world view, the arguments for the appellant are academic?
Yes, yes, yes. Probably put far more quickly than the half hour I've taken.
On the facts of this case, you'd say they're academic.
Yes.
But when we go back and scratch our heads about the grounds of appeal, it's the principled answer that we need to concentrate on, which could, in some circumstances, arise in cases which are not academic.
Possibly. I wouldn't sort of say it never could. I mean, in terms of hard-edged law, a hard-edged question of law, I would respectively endorse everything that was said in Norton. But in terms of the very hard-edged question of law, but yes, there might well be a case. I mean, that's the problem with these cases. They are all fact sensitive. A case could come along where it might have made a difference. I'm trying to think if I think of an example off the top of my head. I mean, the review would have had. There must have been something significant that the reviewer then failed to address, I think would be the answer.
But there's a provision in section 200 and something about the ability to challenge a decision on a review. Can you just remind me what that is?
So that's the section 202 is the right to request a review. And if you don't get your review decision in time, you can then...
In time, there's that. What if you don't like it? Can you just remind me? There's no right to request a review of the decision reached on an earlier review. That's what I had in mind.
Yes, yes.
Subsection 2.
Yes, sorry.
So, okay.
Thank you very much.
Thank you.
Yes, Mr. Cole, do you want to reply?
Yes, thank you very much, my lord. Can I start with section 195 at page 346 in the bundle? In terms of how my friend made submissions seeking to support her submission that suitability is distinct from discharge of the 1952 duty. My submission is that when one reads the duty, which is subsection 2, that the duty is to take reasonable steps to secure that accommodation doesn't cease to be available for the applicant's occupation. Those steps we can see are indeed set out and should be set out in the assessment of under 189A, and the accommodation that is required, that the duty requires the authority to take steps to secure, is suitable accommodation, because we can see that by reference to subsection 8A is the way in which the authority can say that the duty has come to an end because the applicant has a suitable accommodation available for occupation and it's got the required length of time. So in order to discharge the duty, they have got to take reasonable steps to help secure suitable accommodation. That suitable accommodation doesn't cease to be available for occupation. And when we look at the review decision, paragraph 87 of the review decision, my lord will find it the core bundle 129, paragraph 87, that the authority's decision is that the accommodation at 124 Kenilworth Road is suitable so that the housing duty is ended. So it ties suitability to the discharge, which is the consequence of indeed the operation of the statutory provision. So a decision bringing the duty to an end because suitable accommodation has been secured is a discharge of the 195 duty. It's the approach taken in the review decision, and therefore it's not open in my submission for the authority to say, well, suitability is distinct from discharge. It's covered by section 210 and there is no cross-reference to section 189A, and therefore Norton applies. In my submission, that doesn't, given that the suitability is of the accommodation is linked to the discharge and indeed brings about automatically brings about the discharge through subject to notification, but it brings the duty to an end. It follows therefore that the requirement of subsection 3 is engaged. My Lords raised questions in respect of the right to request a review under section 202, page 348, and in particular the right to request a review under 2021BC, being an amendment introduced by the Homelessness Reduction Act of 2017, giving a right to request a review of the decision as to the steps that they are to take under section 195(2). I agree with my learned friend that it relates to the steps that are required that will be set out within the PHP, if I can call it that. That's what I commonly referred to, the housing plan. And that plan, there is no right to request a review of the assessment under 189A. The fact that there is a right to request a review under F in relation to the offer in discharge of their duty under any of the provisions, then it does not mean, in my submission, that the suitability review is limited to a pure suitability assessment, absent consideration and assessment of the impact of section 1953 and the requirement to take into consideration a lawful assessment that should have been prior to the review carried out by the authority and complies with the necessary requirements. In terms of the previous authorities, the High Court authorities, the only, just reviewing them briefly over lunch, the case of XY relates to a decision where the authority had accepted the main housing duty, not just the 188 duty, and therefore, but it wasn't argued in that case that there was an alternative remedy because the provision relates to suitability of accommodation provided in discharge of duty. It was seen as it was the first case considered by the courts in terms of how section 189A operated. Other than that, the other cases, as I can see, all relate to 188I provision of interim accommodation pending determination as to what duty, if any, is owed. Finally, my lords, the provision, my learned friend accepted that in essence the argument that if a suitability review has been conducted, it renders academic the section 189A assessment, or the requirement to carry out the 189A assessment. My lords, if that is right, that it does, the suitability review, when faced with a breach of the duty under 189A to undertake the assessment and set out the steps to be taken for it to be put in writing and agreed with the applicant, if that is academic, because the authority undertake a suitability review, it renders Parliament could not have intended that as a consequence, because it would result in the provisions of 189A and the subsections under the relevant relief duty, the prevention duty, and the limited duty under 190 being academic and not of any force. And in my submission, that cannot have been Parliament's intention. Accordingly, therefore, the appeal should be allowed. On the question of relief, my lords, my answer to the question of would it inevitably be the same result? Well, what has been denied of what the appellant has been denied is the right to engage with the authority to agree a plan and in light of the assessment, and for that to dictate how the accommodation is identified. And just as it's not been part of my, it's not referred to my argument, my lords will probably be familiar with, indeed, Regulation 7.2, and indeed this case there was a minded to find notification. It's a duty imposed by Regulation 7.2, where there's a deficiency or irregularity in the original decision. The importance within that regulation is that applicants are given the opportunity to make representations both orally or in writing or both. And in this case, the court, in my submission, should protect the rights of the applicant to ensure that there is cooperation and collaboration between the parties, and it should be right from the outset of the determination of the application and prior to discharge, any attempt to discharge the duty that is owed.
When you're referring to Regulation 7.2,
My lord,
is
yeah.
that the review procedure regulation?
It is, my lord, yes.
Which is the requirement that if the reviewer considers there's a deficiency or irregularity
In the original
or
decision.
in the original decision or in the manner it was made, but is minded nonetheless to make a decision which is against the interests of A on one or more issues, the reviewer must notify A that he's so minded. So where does that take us?
My lord, what it enshrines is a right to respond and to engage before the final decision is made, and that's a right that should be protected. Just as that right is of being informed and opportunity to respond to is.
In substance, it was complied with in this case because there was a mandatory letter.
My lord, what I'm saying is that the right to be involved in the assessment and the drawing up of the plan is a right that should be likewise protected by the courts to ensure that what Parliament's intention was, namely that there should have been cooperation and collaboration with the applicant right from the off. And that protection, which is afforded under Regulation 7, is likewise the protection that is given to an applicant to ensure that there is the plan, the assessment and the plan before any allocation or is involved in the allocation. My lord, that should likewise be a right that should be protected by this court, rather than it being determined to be academic because a suitability review has been undertaken. They've been denied that opportunity. That's the simple point I'm making. Unless I can insist any further.
No, thank you.
Thank you very much. Can I thank all concerned for the preparation and presentation of this case. We will reserve our judgments. A draft will be circulated in due course to the counsel and solicitors whose details were supplied before the hearing. Can I stress the limited purposes for which that is done? It's a confidential embargoed judgment. It's only for the purposes of drawing the court's attention to typographical or minor factual errors. It's certainly not an opportunity to argue the case again. We anticipate that any consequential matters can be dealt with either by agreement or by brief written submissions, and we would envisage that the hand down will be remote and that we can finalise an order at the same time as hand down.
Thank you.
Thank you very much.
Alright.